Hey everyone, today we're going to dive into the really fascinating and frankly crucial world of international criminal law. It's a field that's all about one of humanity's most ambitious goals, trying to find justice for the absolute worst crimes you can possibly imagine.
So let's just start with the one question that really drives this whole area of law. Think about it. When mass violence breaks out, when crimes are so awful they just scar the conscience of the entire planet, who do we turn to for accountability? Who can possibly step in when a country's own justice system has completely failed, or maybe is even the very thing causing the crime? So what even is international criminal law? Well, you can think of it as a set of global rules that has two main jobs. First, it makes the most heinous acts illegal on a global scale. But second, and this is the truly revolutionary part, it doesn't just point the finger at countries or abstract ideas. It says that the individuals who gave the orders, the people who carried out the atrocities, they can be held personally, criminally responsible for their actions.
Now, you might think this idea has been around forever, right? But holding individuals accountable on an international stage, that's actually a pretty new idea. For most of human history, whatever happened inside a country's borders was, its own business.
What's so interesting here is how you can see the slow, difficult birth of this idea. For centuries, law was strictly a national thing. The only real exception, piracy. See, pirates operated on the high seas, which is outside any one country's control. So they were declared hostes humanus generis, basically enemies of all humankind. Anyone could prosecute them. The first big attempt to apply that kind of logic to a head of state came after World War I with Kaiser Wilhelm II. The Treaty of Versailles accused him of a supreme offense, but the whole thing had no teeth. He fled to the Netherlands and they just refused to hand him over. The prosecution completely failed. But it was a really important failure because it planted a
The real watershed moment, the point where everything, and I mean everything, changed, came after the Second World War. The unbelievable scale of the atrocities just demanded a totally new answer to that question of justice. And you can really see that idea picking up speed on this timeline. Just look at the jump, from that failed attempt in 1919 to the groundbreaking Nuremberg and Tokyo tribunals only a couple of decades later. These tribunals hammered home that revolutionary idea of individual criminal responsibility. Then, in the 90s, the world was horrified by what was happening in the former Yugoslavia and Rwanda, so the UN created temporary or ad hoc tribunals to deal with those specific conflicts. All of this just built momentum toward that final step in 1998, creating a permanent court for good.
This quote right here from the Nuremberg judgment, it is the absolute bedrock of modern international criminal law. The point is just so crucial. You can't put a country on trial in a criminal court. You can't send an abstract entity to prison. If you want justice, if you want to deter these crimes from happening again, you have to hold the actual people who make the decisions and carry out the orders accountable. That, right there, was the game changer.
So after Nuremberg, but before we had a permanent court, the international community had to get pretty creative. When new atrocities happened, they started experimenting with different kinds of tribunals, creating what were basically laboratories for international justice.
Okay, check out this table. It really breaks down the different approaches. On one end, you've got the tribunals for Yugoslavia and Rwanda, the ICTY and ICTR. The UN Security Council created them directly, and they applied purely international law. Then you've got something totally different, like the Special Tribunal for Lebanon. That came from a government request, and get this, it actually applied Lebanese domestic law. And right in the middle, you get these hybrid courts, like the one for Sierra Leone. That was an agreement between the government and the UN, and it applied a mix of both international and local Sierra Leonean law.
So all of this experimentation, all this legal evolution, from Nuremberg to Rwanda, it was all leading to one place, the creation of a single permanent court that could have a global reach. And here it is, the International Criminal Court, or the ICC, in The Hague. It was established by a treaty called the Rome Statute back in 1998, and it officially opened its doors on July 1st, 2002. Now this was huge, because this wasn't a court set up by the winners of a war, or one created by the Security Council for a single conflict. No, this was a court created by a global treaty, designed from the ground up to be a permanent weapon in the fight against impunity. Okay, so what exactly does this permanent court go after? Well, its power is deliberately narrow. It's limited to what the Rome Statute calls the most serious crimes of concern to the international community as a whole. There are 4 of them, and they're often called the core crimes.
First up is the one you've definitely heard of, a word that was literally invented to describe the ultimate evil, genocide. It's often called the crime of crimes, and for very good reason.
The thing to understand about genocide is the absolute laser focus on intent. It's not just about mass killing. It's about the specific goal, the specific intent to destroy a particular group of people. The acts themselves can be anything from killing and causing horrible harm to more insidious things like preventing births or forcibly taking a group's children away. But if you can't prove that specific intent to destroy the group as a group, then legally it's not genocide.
All right, next up, we have crimes against humanity.
For crimes against humanity, the most important word to remember is context. The acts you see listed here, murder, torture, rape, enslavement, they're all terrible crimes on their own, but they become crimes against humanity when they're done as part of a widespread or systematic attack that's aimed at civilians. That means it can't just be a random isolated incident. It has to be part of a bigger policy or a clear pattern of abuse.
In this image, wow, it really drives that point home, doesn't it? We aren't talking about a single act of violence. We're talking about the kind of utter devastation that comes from a large-scale, organized attack on a civilian population, turning their homes, their lives, into rubble.
Okay, on to our third core crime, war crimes.
Now, unlike crimes against humanity, which can actually happen in peacetime, war crimes, just like the name says, can only happen during an armed conflict. They're serious violations of the laws of war, which are famously written down in the Geneva Conventions. This covers stuff like how you have to treat prisoners of war, protecting civilians, and banning tactics like taking hostages or just destroying property for no good military reason.
This image here is a really grim reminder of what a grave breach actually means. The whole point of the Geneva Conventions is to keep some minimum standard of humanity, even in the middle of a war. And acts like torture or inhuman treatment of prisoners are an explicit, undeniable violation of those basic rules.
And finally, we have the fourth and most recently defined crime, the crime of aggression. This one's a bit different.
Yeah, this one is pretty unique. It's not about how a war is fought, it's about the decision to start an illegal war in the first place. And the key thing here is that this crime targets the people at the very top, the leaders who are in a position to direct a country's political or military moves. It basically criminalizes the act of planning and launching a war that is a clear, obvious violation of the UN Charter.
Now, if you take one thing away about how the ICC actually works, make it this. It operates on something called the principle of complementarity. What that means in simple terms is that the ICC is not here to replace a country's own courts, it's here to complement them. Nations always have the first right and the first responsibility to prosecute these crimes themselves. The ICC is a court of last resort. It can only step in if a country is genuinely unwilling or unable to bring perpetrators to justice.
So, we've gone on quite a journey, haven't we? From a time when justice stopped at the border to today, where we have a permanent international criminal court. The structure for global justice is there. But the biggest question, the one we're all left with, is this. In a world that's still full of conflict, is it enough?